Hello and welcome. I am Chakshu Roy and you're watching Laws in the Making on Rajya Sabha TV. Today on the show, we are discussing the Aadhaar and Other Laws Amendment Bill 2019. The Aadhaar Act of 2016 creates a system for identifying any individual based on a 12-digit number and their biometric information. After the Act came into force, individuals are required to link their phone numbers and bank accounts with the Aadhaar number. The Act also laid down provisions for collecting information from individuals above the age of 5 years. To discuss the bill today on the show, I have with me Mr. Kapil Sankhla, Advocate, Supreme Court of India, and Ms. Roshni Sinha, Analyst, PRS Legislative Research. The bill comes in context of several claims raised on the validity of the Aadhaar Act in the Supreme Court. The bill removes this mandatory use of Aadhaar by service providers such as mobile phones and financial service providers. It also allows children to opt out of the system when they become adults.
The Aadhaar Act 2016 was enacted with the purpose of service delivery and targeted delivery of subsidies by assigning unique identity numbers to individuals. To obtain an Aadhaar number, an individual has to submit his biometric and demographic information. The Unique Identity Authority has been given the responsibility for assigning Aadhaar numbers to individuals and specifying the usage of Aadhaar numbers for delivery of subsidies and services.
The first part of the Aadhaar litigation actually happened, which is the 9-judge bench Constitution bench decision in case Potoswamy, which established that we have a right to privacy in this country. Now, there also this question was there that this Aadhaar mechanism, this architecture is being created for the public good, for the good of public at large. If there are privacy concerns, then we should swallow it. That was the basic idea. The court says no, we can't swallow privacy concerns, and so therefore the attempt or the approach should be not antagonistic, but we should have an idea, an open mind about cooperating with the system to see if there is a manner of working Aadhaar out while not endangering any individual's privacy rights.
In 2017, the Supreme Court held that the right to privacy is a fundamental right under Article 21 of the Indian Constitution. In this context, certain questions were raised to question whether the Aadhaar Act violated the right to privacy. There were further concerns questioning the legality of linking of Aadhaar numbers to various services such as mobile numbers and bank accounts.
Since Aadhaar card were issued at a large scale to the entire population of India by the Unique Identification Authority of India, and it was easily available to each and every person, and there was a perfect identification on the basis of the biometric and the retinal contact. But now these companies has been told that they will not store this data permanently, and moreover this the government of India can also verify that the right person has been opening the accounts in the bank as well as in the mobile companies.
In 2018, the Supreme Court maintained that the Aadhaar Act does not violate right to privacy. It also allowed the linking of Aadhaar number with an individual's PAN number to file income tax returns. However, certain provisions were barred. It is no longer mandatory to link Aadhaar number with mobile numbers and bank accounts. The court also laid down safeguards for enrolling children under the Act. The bill was introduced in Lok Sabha by the Minister of Electronics and Information Technology, Mr. Ravinder Prasad, on June 24, 2019. It replaces an ordinance promulgated on March 2, 2019.
Usage of the Aadhaar number is used extensively for delivering government services. Kapil, I wanted to start the program with you. Sure. What is the history of Aadhaar, and why was the Act challenged in the Supreme Court of India?
Wonderful. You see, let's put it top heavy. Let's just say that this is a social security number, because that is what the first challenge was. That whether the purpose as envisaged by the government, that it is going to protect and make sure that the funds of the government percolate down to the needy and the poor. Is it going to meet that, or whether it will be a social security number? Can it be used for the internal security of India, etc.? So that's the top heavy question. So the purpose at the first instance of Aadhaar was to ensure that the funds, the largesses of the government, percolate down. There are no dummy accounts. There are no people who really do not exist who are enjoying the benefits, that the money is not diverted. that the largesses are not diverted. That was the first. But then the whole purpose of Aadhaar was enlarged. The purpose was now to put a unique number identifying a unique person. So the idea was to know whether a person genuinely exists or not, that's one. Whether that person is an Indian or not, second. And how many people are dummy account holders or dummy humans, people who do not exist, people who are there only on paper. Okay. So this was the purpose that was enlarged. With this came the questions of privacy concerns. So the questions were raised that whether these details, accounts, your biometrics, your details can be used by some other government agency for some other purpose, which could be income tax, which could be crime branch, which could be the police, etc. Can the government allow policing through your biometrics? That was the concern. So the concern was whether this data can be misused. There were issues where the data was hacked into, was distributed online, were sold unauthorizedly. So there were a lot of issues. So in another program, I have already said that these concerns would be met. The thing is that when there is some technology and upgradation that happens, there is usually some concern which is always with that. When you had the mobile phones, for example, were launched, there were concerns that they could cause cancer, that they can be hacked, that your information could be distributed illegally. It is the same with the system. The protection mechanisms are being put in place, which has been put with this act also.
Okay. So, Roshni, Kapil raises some interesting points. You've looked at the, Aadhaar Act extensively. Can you just tell me as to, when the Supreme Court was looking at the validity of the Act,
right,
what were the broad points that the court brought up for its consideration?
Sure. So again, if I could just take a couple of steps back and just, broadly begin by again highlighting that the idea of the Act was to uniquely identify a person based on their biometric information and their 12-digit Aadhaar number. Now, soon after the Act came into force, various notifications were issued by the government requiring mandatory linking of Aadhaar number with bank accounts, mobile phones, PAN cards, and the requirement to quote your Aadhaar number while filing your income tax returns. Now, the validity of all of these notifications requiring mandatory linking, as well as the larger scheme of the Aadhaar Act, as he mentioned, were all challenged before the Supreme Court. And some of the questions before the Supreme Court was it violating an individual's right to privacy, which just a year before had been declared to be a fundamental right?
So let me just stop you there.
Sure.
The Aadhaar Act does not make it mandatory for any of us to get Aadhaar number, right? I mean,
right.
It is incumbent upon me or anybody else as to whether we want to enroll into the Aadhaar system or not. And these notifications, since they were for daily use items, was the idea to say, not only is it voluntary, but also if you want to avail these services, you need to enroll your Aadhaar number or get an Aadhaar number and get enrolled.
Right. So I think a lot of it was, in terms of, there are two parts to it. One is in terms of availing government subsidies and welfare schemes. There was a requirement to authenticate your identity through Aadhaar. On the other hand, a lot of mobile service companies and banking companies were requiring Aadhaar as a part of their KYC requirements to validate the identity of a person. So it was on this aspect, whether as a part of the KYC requirement, can you require mandatory linking of Aadhaar number, that this question went to court.
Okay.
So if I could just conclude, so the court essentially then said that, while the Act is not violating a person's right to privacy, it still went ahead and struck down some provisions. And on the question of whether, this mandatory linking was okay or not, the court essentially said as far as it concerns government subsidies and welfare schemes, it is okay to require authentication via Aadhaar. But where it concerns service providers, which require mandatory linking as a part of their KYC requirement, it can only be done if it's backed by law passed by Parliament.
Okay. Kapil, so clearly 2 or 3 different things are happening. One is the Aadhaar number is being used extensively for delivery of services.
Right.
And, you talked about, the kind of efficiency it kind of brings into the delivery.
Right.
You want to elaborate a little bit more, because you talked about deduplication, because earlier we used to have ration cards. One family could have 5 ration cards and go and claim benefits under those ration cards. So what's the advantage that Aadhaar is offering onto that older system?
Fantastic. So that's one small part of it, that probably somebody would have multiple cards, ration cards, other government cards, and misuse the same. That was one. But the larger thing was that there were many employees who did not really exist. They existed only on paper, where contractors and subcontractors were taking benefit. So this was with MCD, cleaning, etc., etc. So that was also a huge chunk of it. Also, the rice, the government, the commodities, etc., that were being distributed as on subsidized rates were actually being sold in the black market. So this has the potential and has effectively stopped majority of those kind of illegal transactions, trades, as well as dummy people, as I just said.
So bogus account holders, bogus people on the employment rolls of government agencies, and one of the users could be you identify that, if you say that you're on the rolls, you're identified that you're on the rolls.
So the bogus part is the second part. Now that's the criminality of it.
Okay.
That somebody could create a false identity and either park funds for himself or other people or rotate funds.
Okay. Roshni, very quickly, give me one highlight as to what the Supreme Court said about the validity of linking of Aadhaar to the PAN card.
So the court essentially said that there were concerns of duplication there as well. So the court, while looking at these various schemes and mandatory linking with various schemes such as PAN cards and mobile accounts and bank accounts, looked at these separately and said that the larger public interest element is satisfied with respect to mandatory linking with PAN card, but it is not satisfied with respect to linking with bank accounts and mobile phones. And that was the basis on which it said that it needs to be backed by law passed by Parliament. So that was the broad rationale.
Okay. So the court makes a distinction between services by the government and services by private providers.
Right.
Okay, great. It's time for us now to head into a break. When we come back, we will discuss the different provisions under the bill. When we come back, we will discuss the different provisions under the bill. Welcome back. On the program today, we are discussing the Aadhaar and Other Laws Amendment Bill 2019. The bill makes amendments to the Aadhaar Act 2016, the Indian Telegraph Act of 1885, and the Prevention of Money Laundering Act of 2002.
The Supreme Court ruled that the use of Aadhaar number by private entities such as mobile service providers and financial service providers violates the right of privacy. The 2019 bill states that an individual may voluntarily use his Aadhaar number to establish his or her identity when obtaining services from private entities. Such authentication is only mandatory in instances where the Parliament has made a law permitting this use of Aadhaar number.
The primary concern is data aggregation. Suppose every signal input of when authentication is taking place is stored centrally in a database. That makes it that much easier for an individual who is just looking at the data stored and will be able to figure out whether a person has entered the court, whether a person has entered the parliament, whether a person has bought something at a shop, whether a person has withdrawn money, whether a person has gone to a particular club, because every payment will be associated. Now, if all these individual silos of data, which is existing today, but they are not aggregated together, will now become easier to aggregate. If that happens, then we can profile an individual just by looking at his Aadhaar data. That is the essential concern, that one's individual privacy will not be private anymore just by looking at the authentication records stored in the CIDR. That is the essential of the privacy concern that is there stemming from Aadhaar.
To safeguard enrollment of children between 5 to 18 years under the Aadhaar Act, the Supreme Court ruled that it is necessary to take the consent of the child's parents or guardians for enrolling under the Act. The bill states that this consent is necessary. It also provides for the child to cancel his Aadhaar after turning 18 years.
In the proposed law, there is a provision that children can opt out from the Aadhaar after they are mature, they are over the age of 18 years. And this is as per the legal provisions that children who have given their consent through their parents, and once they are mature, once they are able to take the decisions, after that opportunity is given to them so that they can either continue or they can exit from the present system.
under the Aadhaar Act 2016, Prevention of Money Laundering Rules 2017, provides for mandatory linking of Aadhaar number with bank accounts and for blocking of bank account if linking is done within 6 months. The bill changes this to state that persons with the license to maintain a telegraph, bank or financial institution can use either Aadhaar number, passport or document certified by central government to establish identity of their client.
Roshni, before we went into the break, one of the things that we were discussing was as to how the Supreme Court judgment made a distinction between usage of Aadhaar for delivery of government services and usage of Aadhaar for establishing KYC norms for financial services, loans or any other purpose.
Right.
So what is the bill doing to address that?
Right. So like you said, because the Supreme Court made that distinction, the Parliament had to essentially pass a law enabling the use of Aadhaar number for private service providers. So what the Aadhaar bill now does is to amend also the Telegraph Act and the Prevention of Money Laundering Act, which will enable Aadhaar to be used as one of the permitted identification methods along with your passport or any other identification that the government notifies. So there is a choice being provided to the consumer as to what form of identification they wish to provide. One of the second thing it does is that it allows for offline verification of Aadhaar number. And the idea is in the ordinary process, when you are authenticating your identity through the Aadhaar number, you're supposed to submit your biometric information to a central data repository. Now, the offline verification is going to circumvent that and allow for verification without having to submit your biometric information. A third change it brings about, which is again flowing from the Supreme Court's verdict, is to allow children who are enrolled under the Aadhaar program to opt out once they become adults, which is when they turn 18 years old. There are some other provisions as well in terms of, the exceptions to the general clauses on secrecy and confidentiality of identity information under Aadhaar, which is that you can disclose it in the interest of national security or if a court orders it. The court had recommended certain tweaks to ensure that a certain level of authority authorizes those disclosures. Those changes have been made as well. So now it's based on the order of a high court and not district court. Similarly, disclosures in the interest of national security can only be based on an order or direction of a secretary and not joint secretary or above.
So the threshold for accessing Aadhaar information is now increased from what it was earlier as per the Supreme Court's direction.
Right.
Okay. Kapil, one of the things that people are talking about is the voluntary usage of Aadhaar.
Right.
Now the law will now allow for you or me if we want to use our Aadhaar, but nobody will be able to force us. You want to talk a little bit about that?
Right. So there are three aspects of it. One is, of course, as you said, the opt-out feature. The second is the opt-out feature for a child who attains the age of 18 years and above. And the third is the voluntary use. So as first opt-out feature is very clear that you can choose to opt out, there would be a window period, etc., which may or may not be granted by the government, that would be decided, but that opt-out feature would be there. The second part of it would be that a child who attains the age of 18, maturity, may opt out, may choose to opt out if the consent has been given by the parents. But where the consent has been given by the parents would be informed as to for what purpose and for what services, etc., the biometric and other Aadhaar details will be used of the child. So that's the second part of it. The third is the voluntary use. So the aspect here is that if I do not want to use my Aadhaar card or the Aadhaar number, if I want to opt out of it or I do not want to use it as it is said. So there would be other viable system which would be available to me. There would be an alternate and viable system.
Okay.
So that would be the third part of it.
Okay. So what you're saying is, I was a child, of 6 years of age. The law requires me to get an Aadhaar. My parents enrolled me into an Aadhaar. When I attain the age of majority, which is 18, I have now a decision to make, which is, do I want to still be in the Aadhaar system or I want to opt out of it? So that's one. The second thing that you're saying is, Aadhaar is not the only way of verifying your identity.
Right.
So if I now want to open a bank account, I can go to take my passport or my voter ID card or any other ID which is specified.
And viable, right.
Yeah, any other viable ID which is provided and I can use it. Great. Roshni, so are there any penalties that are being provided in case somebody goes ahead and misuses Aadhaar information of people?
Right. So the penalties are already specified in the Aadhaar Act. One of the things that the bill is looking to do is to ensure that the players in the Aadhaar ecosystem do not misuse this data, or ensure that there is enough disclosure of data when required. So
for example, who are the players in the Aadhaar ecosystem?
So it could be your enrolling agencies, the requesting agencies for authentication, etc. So these are the players in the Aadhaar ecosystem who could possibly misuse the data. So one of the things that the bill is seeking to do is to ensure that, in case there is any failure to comply with the directions of the UIDAI or furnish information that is required by the UIDAI, there are heavy penalties that could be imposed going up to 1 crore rupees, and there is a continuing fine as well. So that's some of the ways in which the bill is changing the penalties to the Act.
Okay. Kapil, one of the things that we always try and understand on the show is when Parliament is passing a legislation, what is going to be the impact of that legislation on the citizens? What do you think is the intended impact that this legislation is trying to achieve?
Could I just add on to what
Sure.
Roshni was saying? See, the penal consequences are there, but what has also now to be seen is there some way to make good the damage suffered by a party? So the bill at present still lacks that. The penal consequences are there, but how do you make good the damages suffered by the affected party?
Okay, so what you're saying is that an enrolling agency misused your data, the agency gets fined, but it was your data or a data of other people who was got misused. So what happens about that? Okay.
Yes, because the only way then would be file a civil case or a criminal case, which becomes a very, it's not a very viable proposition.
Okay.
And answering your question, how does this benefit? So at one, this unique identification number helps the security agencies. It helps to ensure that the government funds, largesses, the government services percolate down to the needy and the people for which it was meant for. The third is it creates a unique ecosystem. When somebody says that, the data is with the government, it can be misused, as somebody just said, that, it's been aggregated and is with a particular agency. That data is already available with private agencies. Once you're on an Android phone or an iPhone, or when you're on Facebook or LinkedIn, etc., you're using any app, all that data is already available.
Okay, fair point. Roshni, you want to close the program for us by giving us the impact of this legislation?
Sure. I want to just quickly make that one point that, one of the key things that this bill is also looking to do is to enable individuals to now file complaints,
right.
Which was a provision that wasn't there in the original Act, and the Supreme Court had highlighted that. So essentially the bill is incorporating or aligning itself with several of the recommendations or observations of the Supreme Court, and that's what the bill is looking to do.
But that's a pointing out mechanism. That's not a damage provision.
Sure.
Perfect. One final comment on the impact, Roshni, as to what the impact of this legislation is going to be.
I think one of the aspects will be that, the bill is incorporating many of what the, the things or observations that the Supreme Court had. There are some provisions where there could still be, some concerns. In terms of whether the government is actually allowing you sufficient identification alternatives, because it says passport or other identifications that is notified by the government. The question is whether, in the absence of a notification, is Aadhaar still being mandatory at the end of the day if there is no passport available? So those are some of the questions.
Great. Thank you. But that's all the time that we have on the show today. Thank you, Kapil and Roshni, for joining us on this discussion. It is time for us to end the show. You can watch the show on the RSTV page of YouTube. We will be back with a new issue and a new episode. Keep watching Rajya Sabha TV.